I've represented people who made one small mistake that changed their entire life, not because they were guilty, but because they didn't understand what to say when police came knocking. Let me give you an example. A man I once advised, let's call him Eric, heard a knock on his door one evening. Two officers were outside. They said, "We just need to take a quick look around. It'll only take a minute." Eric didn't want trouble. He stepped aside, trying to be polite. 10 minutes later, they were opening drawers. 15 minutes later, they found something that wasn't his. Something a visiting relative had left behind. That quick look turned into a criminal charge. And here's the truth most people don't realize. The most dangerous moment of a police encounter isn't the arrest, and it's the decision to let them in. Because once they cross that threshold, your control evaporates. Everything that happens inside your home becomes evidence. Every object, every scent, every statement. And if you don't know how to assert your rights calmly and correctly, you can't undo what happens next. So in this video, I'm going to give you 5 lawyer-tested strategies you must know anytime police ask to search your home. These aren't tricks or loopholes. They're constitutional principles designed to protect you, but only if you understand how to use them in real time. By the end of this, you'll know how to keep your composure, protect your privacy, and prevent a simple visit from becoming a legal disaster. Let's start with the most important principle. Tip 1. Never give consent unless they have a warrant. Here's the problem. Most searches happen not because police have a warrant, but because people voluntarily give permission. You might think, I don't have anything to hide, but legally that's irrelevant. What matters is control. Once you consent, you give up the strongest constitutional shield you have, the Fourth Amendment right against unreasonable searches and seizures. Let's break that down. The Fourth Amendment doesn't ban all searches. It bans unreasonable ones. A search with a warrant is considered reasonable because it's reviewed and signed by a judge, but when you say, sure, come in, you make it reasonable by your own consent. That means any evidence they find, even if unrelated, can now be used against you. Here's why it matters so much. When police request entry without a warrant, they're testing you. They're trained to use polite, casual language to lower your guard. They might say, we just need to check something real quick. They might mention a complaint, a noise issue, or say, we got a report of something suspicious. The goal is to create social pressure, to make you feel that refusing would look guilty or disrespectful. But here's the legal reality. Refusing consent is not suspicious. Courts have repeatedly ruled that exercising your rights cannot be used as evidence of guilt. So, what do you do instead? You stay calm, step outside if you want to talk, and say clearly, "Officer, I do not consent to any searches." That one sentence keeps the entire interaction on record as non-consensual. If they enter after that, anything they find can be challenged and suppressed in court. Now, why does this work? Because consent is one of the few areas of law where clarity saves you. Police know that once they get you to agree verbally or even by gesture, like stepping back to let them in, the line becomes blurred. That's why your job is to keep it clean, clear, firm, and polite refusal. If they have a warrant, ask to see it. Physically hold it in your hands. Read it. Make sure it's signed by a judge and check that it lists your address and the exact area to be searched. Warrants can be limited. For example, it might authorize a search of your garage, not your entire house. If the scope is exceeded, evidence outside that scope can be thrown out. And never forget, if they have a valid warrant, you cannot stop them from searching. But you can stop yourself from making their job easier. Don't volunteer information. Don't point things out. Just say, I'm going to remain silent and I'd like to speak with my lawyer. That brings us to the next critical rule. Tip 2. Never lie, but never volunteer information. This is where most people destroy their defense before it even begins. When police arrive at your door, your instinct is to talk, to explain, to clarify, to show you're cooperative. But what you're really doing is providing context that can later be used to justify a search. Here's how it works behind the scenes. Under the plain view doctrine, if an officer is lawfully in your home and sees something illegal, even in the corner of his eye, that can trigger probable cause for a full search. Now imagine you've let them in and start chatting. You mentioned that a friend stayed over, that you misplaced some prescription meds, that your cousin's been helping with repairs. Every sentence adds a data point. If they later find something questionable, those statements build a story, and that story can be used to connect you to the evidence. But here's the legal danger most people miss. Lying to law enforcement is a crime. Under 18 U.S.C. Paragraph 1001, any materially false statement made to a federal officer can be prosecuted, even if you weren't under oath. Some states have similar statutes for local police, so if you say something inaccurate out of nervousness, that alone can turn a conversation into a criminal investigation. The solution is balance. Be respectful, but brief. Confirm your identity if required, then stop talking. Here's the line I advise my clients to use. Officer, I want to cooperate, but I'd prefer to have my lawyer present before answering any questions. That statement does three things. 1. It signals you're not resisting. 2. It stops further questioning legally. Under Miranda v. Arizona, once you invoke your right to counsel, they must stop interrogating. 3. It prevents you from creating self-incrimination risks through small talk. Now here's why that works psychologically. When you project calm and certainty, it removes the tension officers rely on to push boundaries. You're not acting defensive, you're acting informed. Most officers know the difference between someone hiding something and someone who understands the law. They'll respect it even if they don't show it in the moment. Let me emphasize this. Your silence cannot be used against you. The Supreme Court has repeatedly affirmed that remaining silent or asking for counsel is not evidence of guilt. The key is to state it out loud. Otherwise, silence alone can be ambiguous. Once you've invoked your right, you've drawn a bright legal line. And remember, your words are not the only evidence. Your tone, your body language, your gestures, they all feed into how the encounter is documented. That's why composure is power. Breathe slowly. Keep your voice steady. Don't argue. Just calmly assert your rights. Because the legal system doesn't protect people who panic. It protects people who know the rules. You now know how to stop a search before it begins by refusing consent and keeping silent. But there's a layer deeper that most people never think about. How officers get around those exact protections. Police officers aren't villains. They have jobs to do, but the law gives them flexibility on what we call exceptions to the warrant requirement. These are built-in cracks in the Fourth Amendment that let them enter or search without your consent if certain conditions exist. If you don't understand these exceptions, you'll think you're protected when legally you're not. That's why this next section is about how to close those loopholes before they're used against you. Tip 3. Control the emergency exception. This one surprises people. Police can legally enter your home without a warrant if they believe an emergency is in progress. The official term is exigent circumstances. It covers situations where waiting for a warrant might result in harm, destruction of evidence, or escape of a suspect. Let me give you an example. Suppose your neighbor calls 911 and says they heard screaming in your house. Officers arrive, knock, and no one answers. They can legally enter under the emergency aid doctrine, not to investigate a crime, but to ensure safety. Once inside, however, anything they see in plain view becomes admissible evidence. So how do you protect yourself? First, understand that your demeanor matters more than anything. If you appear calm, alert, and in control, officers lose the legal justification for an emergency. They can't claim exigent circumstances if there's no visible or audible crisis. That's why when police knock, you should always open the door to speak without letting them in, because silence can give them an excuse. When you open the door, step outside and close it behind you. This one small move establishes a physical and legal boundary. It signals you're communicating, not inviting. If they mention they're responding to a complaint or concern, you can say, "Everything's fine, officer. There's no emergency here, and I do not consent to a search." This statement does two things simultaneously. 1. It removes the emergency justification. 2. It reaffirms your refusal of consent on record. Why does this work? Because the emergency exception hinges entirely on reasonable belief. Once you clearly deny the existence of an emergency and appear physically fine, any further entry becomes legally risky for them. Judges don't like when officers overstep that boundary. Now let's talk about the second part of this loophole: destruction of evidence. If officers believe evidence is being destroyed, say they smell something burning or flushing, and they can enter, but here's the truth. Officers often use claims of smell or sound to justify forced entry. That's why you must never argue through a closed door. Loud confrontation gives them an auditory excuse to say they heard destruction of evidence. Stay calm, step outside, be recorded if possible, and never create noise that can be misinterpreted as destruction or resistance. The emergency exception is powerful, but it's built entirely on perception. Your job is to control perception. Calmness is your best defense. Tip number 4, understand the third-party consent trap. Now we get into one of the most legally complex and most exploited search doctrines, third-party consent. Here's what it means. Police don't need your permission to search your home. If someone else with parent authority gives it, that could be a roommate, a partner, or even a relative staying temporarily. Let's break that down. The Supreme Court ruled in United States versus Matlock, 1974, that when two people share common authority over property, either one can consent to a search, even without the other's permission. That means if you live with someone and they let police in, anything found in common areas can be used against you. The law later evolved in Georgia versus Randolph, 2006, which clarified that if both occupants are present and one explicitly refuses consent, the police cannot search. But here's the nuance. If you're not home when they come knocking, your refusal doesn't apply. So how do you protect yourself from this? You create clarity. both with your household and with law enforcement. First, talk to anyone who lives with you about this rule. Make sure they understand. Never consent to a search, ever. Even if they think it's harmless, even if they believe it's just procedure. Once consent is given, it cannot be undone. Second, if you suspect police might approach when you're not home, say during an ongoing investigation or misunderstanding, notify your attorney immediately. A written statement or voicemail from your lawyer refusing consent on your behalf can become valuable later if evidence was gathered improperly. Here's why that works. In court, everything revolves around reasonableness. If officers can claim they reasonably believed the person consenting had authority, the search can be upheld. But if your lawyer establishes that your refusal was known or documented, that belief becomes less reasonable. It turns into a violation. Now, let's talk about a related trap, the apparent authority issue. This is when someone seems to have control over a space but legally doesn't. For instance, a landlord, property manager, or Airbnb host. Landlords cannot give consent for police to search your private living area. They can only authorize entry for repairs, inspections, or emergencies. If police claim your landlord allowed them in, that search can often be challenged and evidence suppressed. Same goes for hotel rooms. The guest, not the hotel staff, holds the right to privacy until checkout. The Supreme Court confirmed this in Stoner v. California, 1964. So if police enter based on hotel staff permission, that's an unlawful search. Here's what this all comes down to. Shared spaces create shared risk. Whether it's a roommate, a romantic partner, or a landlord, you must control who has access to your space and who might unintentionally waive your rights. Why does this matter so much? Because once consent is given, even if you didn't know, courts generally don't suppress the evidence unless the officer acted unreasonably. And unreasonable is a very high bar. So what do you do practically? 1. Keep private areas private. Bedrooms, safes, and locked containers should always be secured. A roommate cannot consent to a search of your locked room or your personal belongings, only to shared spaces. 2. Maintain physical boundaries. Separate keys, passwords, and locks make authority clear. 3. Make non-consent known. Calmly tell any co-occupant, if police ever come, please don't let them in without my presence or my lawyer. It might sound uncomfortable to say, but it's the kind of preparation that prevents irreversible mistakes. Because once police are inside, you've already lost control. Let's pause for a second. You now understand how to neutralize the emergency justification, block the third-party consent trap. These two alone will protect you from 80% of unplanned home searches. But there's still one more area most people forget, and it's the one that can destroy your defense even if you followed all the other steps perfectly. Because this is where people who did everything right, refused consent, stayed calm, kept silent, still lose their case. Not because of what they did during the search, but because of what they did after it ended. Tip number 5. Document everything immediately. Here's the problem. The legal system doesn't care what you felt happened. It cares what you can prove. If police enter your home, whether or not they find anything, the record of that encounter becomes evidence, either for them or for you, and the first one to document it usually controls the narrative. So let's talk about what that means in practice. As soon as the officers leave, sit down and write everything you remember in detail. Time, date, number of officers, their names or badge numbers if visible, what they said, what they touched, what they claimed to see. If they mentioned a reason for entry, write it word for word. Don't rely on memory later. Small discrepancies can destroy credibility. If you recorded the encounter, and in most states you're legally allowed to record police as long as you don't interfere, back it up immediately. Cloud storage, USB, anything off your device. You want at least 2 copies saved outside your home. Now here's where most people make their first mistake. They start calling friends, posting on social media, or venting about what happened. Never do that. Anything you say publicly can be used to undermine your version of events. Police reports are written to sound professional, consistent, and objective. Your Instagram story, no matter how sincere, won't stand up in court the same way. Instead, your first call should be your lawyer, or if you don't have one yet, a local criminal defense attorney. Even if you're not charged, that consultation is worth every penny. Why? Because lawyers know how to preserve your rights before charges are filed. We can send a preservation letter to the department requesting copies of body cam footage, dispatch logs, and incident reports. If you wait even a week, those can be overwritten or lost. And here's a detail few civilians know. Under most public record laws, including the Freedom of Information Act at the federal level and similar state laws, you have a right to request copies of reports and footage, but only if you do it properly and promptly. Why does this documentation matter so much? Because in court, truth is filtered through paperwork. Judges and juries don't see the emotional reality. They see see reports, affidavits, timestamps, and transcripts. Whoever documents first sets the foundation for that record. When your version is supported by timestamps and detailed notes, your credibility skyrockets. Let me give you an example. I once represented a homeowner accused of obstructing officers during a warrantless entry. The police report claimed he was aggressive, refused to answer questions, and tried to block them. What actually happened, according to his own detailed notes and a neighbor's recording, was that he calmly stepped outside, said, "I do not consent," and shut the door. That written record, made within minutes after the incident, became the anchor of his defense. When we compared it with the officer's later testimony, small inconsistencies, the time they claimed to arrive, the position of the door, their phrasing, all unraveled under cross-examination. Case dismissed. Documentation isn't just about self-protection, it's about control. It turns chaos into order, emotion into evidence. Now there's a final layer here, one that ties all 5 principles together. It's not a legal tactic, it's a mindset. When the police knock, your nervous system fires off alarms. Your heart rate spikes, adrenaline floods your bloodstream, and your body prepares for conflict. That's biology. It's the same physiological response you'd have to danger or confrontation. But here's what separates people who stay in control from those who crumble. Preparation rewires instinct. When you know your rights, you reduce uncertainty, and uncertainty is what drives fear. The moment fear takes over, you start making choices driven by survival, not strategy. You talk too much. You open the door too wide. You forget the phrases that protect you. The most effective clients I've ever seen, the ones who avoid disaster, are not the loud or confrontational ones. They're calm. They breathe. They slow everything down. They know that time is their greatest weapon. Every second you delay a hasty decision is a second closer to clarity. When police realize you understand the law, the tone of the entire encounter changes. They stop improvising. They start following procedure, and because now they know you'll remember every detail. That's why this isn't just about memorizing rights. It's about mastering your own physiology. When the knock comes, inhale through your nose. Hold for 2 seconds. Exhale slowly. That single act disrupts the fight or flight cycle and brings you back into control. From that place of composure, everything else falls into place. You remember the rules, you speak clearly, you don't argue, you don't panic. You just apply what you know. I do not consent to any searches. I'd like to remain silent. I want to speak with my lawyer. 3 sentences that can prevent a lifetime of damage. Let's recap what we've covered. 5 principles that turn panic into power. 1. Never give consent without a warrant. This keeps your 4th Amendment protection intact and preserves grounds to challenge any search. 2. Never lie, but never volunteer information. It's your silence, not your speech, that protects you. Lying creates crimes. Silence creates leverage. 3. Control the emergency exception. Stay calm, appear safe, and remove any pretext for exigent circumstances. Perception is protection. 4. Understand the third-party consent trap. Make sure no one else can unknowingly waive your rights. Not roommates, not landlords, not partners. 5. Document everything immediately. Whoever records first controls the story. Precision today prevents prosecution tomorrow. These are not loopholes. They're the legal boundaries that define fairness, and they only work when you enforce them. Before we end, I want to leave you with a mindset I teach all my clients. The Constitution doesn't enforce itself. It's a tool, and tools only work when you use them correctly. So when you hear that knock, don't think of it as a battle. Think of it as a test and of your calm, your clarity, your discipline. Your home is your fortress. The law is your armor, and knowledge, and this knowledge, is what keeps both intact. If you found this helpful, share it with someone who might not know these rules. Most people don't learn them until it's too late, because your rights are like muscles. The more you use them, the stronger they get. And the next time someone in uniform stands at your door, you won't be afraid. You'll be ready.